hearing in the appeal of the King on the application of Bano against the London Borough of Waltham Forest.
Yes, Ms Davis.
My lords and my lady.
I should begin by saying we're sorry to have been somewhat late. We've been having a rather lively discussion of this case and lost track of time.
Maybe the content of that will become apparent, my lords and my lady. Thank you. I appear for the appellant in this matter with Mr Marshall Williams on my right and Ms Mellon, who sits behind me. Mr Grundy, KC, represents Waltham Forest, together with Mr Mullin and Mr Marn. And the first intervener, Shelter, is represented by Mr Bates, just on my left, with Ms McGibbon also on my left, and behind her Miss Hyde. There is also a second intervener for London Borough Councils and the Social Housing Law Association, who have permission to intervene with written submissions only, and Mr Hutchins and Miss Polymac represented them, but we don't think they're present in the court. No. So there we are. In terms of housekeeping, my lords and my lady, first of all, the written submissions from the second intervener were not in the bundle because timetabling didn't account for that, but we presume that you have those.
Yes, we have it.
And also not in the bundle and uploaded onto the portal by us yesterday afternoon was the full text of the current version of Section 188 of the Housing Act 1996. Again, I don't know if you have that. If not, we have hard copies.
Yes, we have been sent. Yes, we have.
One of the things I found rather confusing is that some of the submissions refer to earlier versions of the legislation,
yes,
and some of them refer to the current versions of
yes,
the legislation, and it wasn't entirely clear to me which version of it we should be looking at in the bundle, but perhaps you'll clarify that as we go through.
I intend to, unless you'd like me to clarify at this point.
No, just to flag up that.
I'm very grateful, my lady. My lords and my ladies, as you know, this is an appeal against the order of the Court of Appeal and the judgment of the Court of Appeal made on the 7th of February of last year. And it's an appeal on statutory interpretation of Section 1937AA of the Housing Act 1996. And we say, and I think it is accepted, that it must follow that the court's interpretation of that subsection would also apply to subsection 6 of Section 193 and subsection 7 of Section 193. And I will deal with my lady's question now. As is obvious from the bundle, the Housing Act, Part 7 of the Housing Act 1996, which deals with homelessness functions, has itself gone through numerous amendments, about 10, since it was first enacted in 96. The iteration that applied to my client is that was in operation between 2012 and April 2018, and that's because she applied for homelessness assistance in January 2017, although the events that we're looking at occurred in 2020 when there was a new iteration, but the iteration that applied to her was that between 2012 and 2018, and I can tell you where it is in the bundle.
Yes, but the transitional arrangements then for the new amendments was that they didn't apply to existing applications.
Yes,
right.
Yes. So that is pages 452 through to 491 in the bundle. That is the version that was applicable to my client.
So 452 to what, sorry?
I'm sorry, 491.
Thank you very much.
The current version came into force in April 2018 as a result of the Homeless Reduction Act, and as my lady said, there are many references in the written submissions to the current version, which doesn't apply to my client, but in terms of statutory interpretation, then obviously we're drawing attention to it. And just to add to the complexity, there are amendments expected to come into force from the 1st of May as a result of the Renters' Rights Act, although we haven't yet had a commencement order or transitional provisions dealing with that, but they don't affect the issue of statutory interpretation before the court today.
And can you just give us the bundle reference number for the current version, the April 2018 version, just so...
We don't have the full version. What we have is the extracts of the different sections, and those are at... page 492 through to 503 contains the new sections that were inserted by the Homelessness Reduction Act, and the section 193 as amended by the Homelessness Reduction Act and in force as of now is pages 534 to 536.
Right. And so for the purposes of the argument, which version shall we be looking at?
For the purposes of the law applicable to my client and therefore the argument, the full Part 7 pages I gave you a few minutes ago, 421, 429.
And where
Sorry,
within that?
I'm being
452
corrected.
to 491.
Yes, yes. Yes, I've got it.
Yeah, but we're concerned with section 193. Where do we find that?
The applicable version of section 193 is at page 465.
Thank you.
So that is 465 over to 466 is the 193 that applied to my client. So the subsequent, the current version and the version to be brought into force are in front of you for the purposes of your statutory interpretation powers rather than applicable to my client.
And could you help me with section 202 in the version applicable to your client?
Yes, I can. So section 202 is 477
Thank you.
to 478. And section 202 currently in force from April 2018 is 559 to 560.
Thank you.
And my lords and my ladies, as you know, the principal issue in this appeal is whether the main housing duty, which is contained at section 195 section 2, ceases automatically or requires a decision. And if it does require a decision, the second issue, which is ground 2, is whether that can be met by something that has been called a prospective decision, i.e. a decision before all the facts have taken place. If my lords and my lady are with me on grounds 1 and 2, in other words, that it doesn't cease automatically and there isn't a prospective decision, then ground 3 raises what would be sufficient to be notification of a decision about the facts that have happened, and that turns very much on particular letters sent to my client and whether the right to review must be notified. In terms of my submissions, my lord and lady, I propose to make a couple of short introductory remarks, go through the facts, briefly take my lords and my lady to make a few remarks about the history of the statutory provisions without dwelling on those for too long, and then make submissions on the principles of statutory interpretation, which I'm feeling I don't really need to make to this court, but I'll draw your attention to the written case, and then submissions on grounds 1, 2 and 3. So just in terms of two matters that arise and I should deal with before I get into the substance. One is a matter of alternative remedy and delay, which is very much part of the respondent's case. And we say, quite simply, that if we are right, there is no issue of alternative remedy or delay. Our judicial review was against the respondent's decision of the 30th of May 2023. We're going to look at it, but it's page 243.
Sorry, the 30th of May
2023. And that decision was a decision that the Section 193 duty had ended in June 2020 and had not been owed since then. So we are challenging that decision. If we're right, therefore, then the Section 193 duty was not ended in June 2020, which is the respondent's contention. And if we're right, the respondent's decision of the 30th of May 2023 is wrong in law, and our proceedings were issued within 3 months. They were issued on the 5th of September 2023, and so we say there's no delay. If we're wrong and the respondent is right and the duty did in fact end, as they contend, either in June 2020 or in October 2020, which is ground 3, then we accept that at that time the appellant had an alternative remedy, which she didn't avail herself of, and we accept that the judicial review, any judicial review issued in 2023 is long out of time. That's not our challenge. Our challenge is to the decision in May 2023. So we say the issues of alternative remedy and delay are not contentious in this appeal. It all turns on this court's decision about the decision of the 30th of May 2023.
Is the decision of the 30th of May capable of being reviewed under Section 202?
We say not.
Why not?
Because it was not a decision that fell within Section 202. It was in response to, and we can look at it in a moment, it was in response to representations that the duty was continuing, and the decision itself, page 243, responds to those representations. Deals with the contentions that at that time were being put to Waltham Forest, which is that the offer letter was defective, and I will deal with that separately if I may. But then at page 245, about 5 paragraphs down, the paragraph starting, I do not agree that the council did not discharge duty towards Mrs Bano in June 2020 or still owes Mrs Bano a duty under Section 1932 of the Housing Act.
Isn't that a confirmatory decision? Confirming that the duty had ended at an earlier stage? Why not?
Because it doesn't go through the various elements. It doesn't make, I'm sorry, I'll go back a stage. Because what was being said to Waltham Forest is that the offer letter was defective.
And sorry, that's a reference to what was written to Waltham Forest. Do we have the bundle reference to that?
I'll go back. I'm sorry, I'm jumping around. So the representations to Waltham Forest are at page 242. And that's an email of the 15th of May 2023.
So the letter, the 30th May letter, is a response to that email.
It's a response to that email. And the substantive two substantive paragraphs, you will be aware that possession proceedings were commenced. The letter discharging duty is attached, and that seems to have been and that we can see from the attachment is the offer letter of the 10th of June. The letter does not, however, explain the provisions of Section 195A, subsection 2, and as such does not discharge the Section 1932 homelessness duty, brackets, Norton and Haringey. Please confirm you agree that your Section 193 duty towards Ms Bano continues and you will accommodate her as such. So the difficulty that Waltham Forest had at that point is that it's not disputed that the offer letter of, it's actually the 11th of June 2020, was defective in that it had failed fully to explain to Mrs Bano the effects of Section 195A. My Lord is nodding, so I don't think I need to explain what the defect is. It must follow, therefore, that Waltham Forest could not make a lawful decision that the duty, even 3 years later, that the duty had ended.
The method of challenging that is by a review.
Yes, it might not be a lawful decision, but it might nevertheless be a decision.
Sorry?
It's a reviewable decision.
Under Section 202.
Under Section 200.
Well, the Waltham Forest aren't treating it as such. They're not saying that. They're not saying we now make a decision that our duty is discharged.
But my anxiety is that I find it difficult to see how you can have a whole series of confirmatory decisions, each of which gives rise to a new 21-day period.
Well,
and I have difficulty actually with a confirmatory decision right from the very start, giving rise to a 21-day period. either the duty potentially comes to an end if the conditions aren't fulfilled, if the offer isn't accepted or if the offer is refused, and that is the end of the duty. And I'm not quite certain how you can have this thing called a confirmatory decision afterwards. You've already decided, and it then gives rise to the difficulty that you have a whole series of confirmatory decisions, all of which give rise to another 21 days.
So 3 points on that. The first is that we say that this letter cannot be such a confirmatory decision.
Which letter? The 30th of May?
The 30th of May 2023, because it's all put in the past tense. I do not agree that the Council did not discharge duty towards Mrs Bano in June 2020, or still owes Mrs Bano a duty under Section 193. I do not accept that the Council should go back 2 years to accept that the offer made on the 11th of June 2020 to discharge duty towards Mrs Bano is not correct. And at the bottom of page 246, the Council, considering the above, the Council's duty was legally and lawfully executed. So it is not a decision that there was an offer letter in June 2020, nothing has happened for 3 years, but 3 years later we are now making a confirmatory decision that the duty was ended. It's not put in those terms. And there is no, if it was, then it should have contained the opportunity to request a review of it. And indeed, insofar as it deals with a review, it's treating the email of the 15th of June as a request for review, because it says halfway down page 246, the request for review is out of time and a review will not be set up. That's the first thing. The point about a series of confirmatory decisions, that's not our case. Our case is that there has to be 2 decisions and no more than 2 decisions. One is the decision on the offer. It is contained in the 11th of June 2020. And the other is a subsequent decision, and we don't use the word confirmatory. We say that is a difficult word. A subsequent decision that takes into account, that decides whether or not the duty has come to an end, and that decision takes into account the offer letter, including the lawfulness of it, and takes into account events that have happened since the offer letter, such as whether there was refusal or acceptance of the offer, whether indeed the offer letter was sent to the applicant, and that's a second decision. We don't say that there's a further series of decisions to be made. We say that is a second decision, and the correct interpretation of Section 193 is that that decision is made subsequent to the offer letter.
So although you said that the decision of the 30th of May 2023 is the decision that you are challenging, that you seek to challenge in judicial review proceedings,
yes,
that is because you say it's absolutely not a decision taken within this regime, or
yes,
a reviewable decision taken within this regime.
Yes.
It's not one of the decisions which is capable of review under Section
yes,
202. So I think both sides are saying it's either the 11th of June 2020 offer letter, or it's nothing, or there hasn't been a decision. So is the debate between you whether that offer letter itself contains the decision that the duty is coming to an end, if I can use a nuanced tense, because it will come to an end. It is coming to an end, comes to an end whether you accept or refuse the property, and that's it.
So the respondent says that once there is an offer letter, either matters automatically cease once there have been events post-offer and there is no need for a decision, or and that's what I challenge in ground one, or that
So no need for your second decision, because the first decision will have been made.
That's what the respondent
Yes,
says.
I just wanted
yes,
to be clear.
And
so they're not saying there isn't a decision, they're saying there is a decision, to issue the offer letter.
Well, I will leave Mr. Grundy to make submissions about whether or not he says that's a decision.
Okay.
That's very much for him. But he says following the offer letter, however he characterises it, then matters happen and then the duty automatically ceases. And he says, alternatively, and the Court of Appeal accepted both submissions, so the Court of Appeal say, alternatively, the offer letter is a decision, it is a prospective decision, and events subsequently happen. And in respect of a prospective decision, that, which we challenge in ground 2, that prospective decision contains both the decision on suitability and on the ending of the duty prospectively. I'm so sorry.
I wonder if you have to characterise it as prospective. I mean, could one not view it as a decision that we are performing our duty to you, or we are fulfilling our duty to you by offering you this accommodation?
Well, that's the characteristic that comes from the respondent and the Court of Appeal accepted. It's very much my submission within ground 2 that that is not appropriate because prospective essentially means in anticipation or expected, but that there are a series of events after the offer letter that may or may not occur. So we say that's the wrong language.
But the reality is the Housing Department have obviously considered the case of the appellant. They've considered what accommodation is available to house her and her dependents, and they have decided to offer her this accommodation in Derby. So in fact, there has been a decision taken as to how they are going to perform their duty towards her under the legislation, and the letter is communicating the result of that process.
Yes, and that is a decision, as of, in this case, the 11th of June 2020, that we have decided that this offer is suitable for you. But we say that cannot possibly be a decision about events subsequent to the offer, whether you refused or accepted. It cannot possibly be a decision...
Well, sorry, just on that, I mean, are you now addressing us about the terms of Section 202? Because why isn't it a decision as to what duty, if any, is owed to the appellant?
Because, and I'm sorry, I'm jumping around.
No, we're asking you questions that take you around, but I understood the answer you were giving to my lord to be based essentially on it can't be a decision which can be reviewed because it doesn't fall within Section 202. That's the point I understood you really to be making. And then, if that is the point, I was inviting you to look at Section 202B.
That is exactly my point, and I'm very grateful. First of all, the offer letter, certainly the applicant can request a review of the suitability of the offer when she receives the offer letter or within 21 days of that. And that is under, I'm so sorry, Section 202(1)(g).
Yeah, but my question was directed to 1B.
Absolutely, yes. So we say very clearly that, it is very clear that in terms of her right to request a review under Section 202(1)(b, as to what duty, if any, is owed to her, which my lords and my lady will know the Court of Appeal in Warsami included a decision that a duty once owed is no longer owed. In terms of her right to request that review, a review of that decision, the decision cannot be in the offer letter because a decision that a duty once owed is no longer owed can only crystallise when all the events that a local authority has to consider before they can take that decision have occurred.
But if I may say so, doesn't that beg the question as to what Section 202(1)(b) means? You've built into that account of Section 202(1)(b) that it all has to be looking back to the past, but that's not the language used. It just has to be a decision as to what duty, if any, is owed. And they're saying, we're making you this offer.
Yes.
For, I've forgotten the technical term now, forgive me, the
private rental
sector offer. The statutory regime is such that you're going to come out of the main homelessness duty that we owe you under Section 193. When you get that offer, whether you accept it or you don't accept it, that's going to be the end of the duty. Why can that not be properly described as a decision as to what duty is owed to you, to that person under Section 193?
Because what the local authority don't know at that point is whether you've refused or accepted it. And we make the point in the written case that there could be a number of events that where a local authority has to make a decision about whether there's refusal or acceptance.
But why? I don't understand why they need to make that decision.
Well, they need to make the decision because it's an element of the statutory regime. So if we go back to 193...
But 202 isn't only concerned with lawful decisions. You can't presume that a decision has to be perfect in order for it to count as a decision. The whole point of 202 is to enable defective decisions to be challenged.
Yes. But what we say is that as of the date of the offer letter, there are certain events that are not known to the local authority because they haven't happened. And I'll come to my Lord Sale's point about how could there be anything else in a moment. But there are certain events. The most obvious is a dispute about whether she refused or accepted, but other events might be if subsequent to the offer letter, events occur that potentially make the offer unsuitable. There's examples in the case law of where people viewed an offer and they were subject to harassment and so forth.
But whether she's accepted or not, I mean, that's a matter of objective criteria under the general law, whether you accept or you don't accept.
But it's a decision, it's an objective decision for the local authority to make. And it's an evaluative judgment for them, just as they make...
That's what I'm struggling with, because under the statutory regime, once they've decided to make the offer, once the offer is either accepted or not accepted, the duty comes to an end. That doesn't seem to require the local housing authority to do anything more. They've set a train in motion by making the offer, and what happens when that offer is either accepted or rejected is governed by the statute. So there doesn't seem to be scope under the statutory regime for the local housing authorities to do anything more.
What happens is governed by the statute, we agree. But the question about whether there is a refusal or acceptance could be a matter of contention. Not always, indeed not frequently.
But hence my putting to you, but that'll be governed by the general law on offer and acceptance. Well, and may not actually matter very much, since the duty comes to an end whether you accept or reject the offer.
I'm so sorry, I interrupted.
No, I'm sorry, I was just saying, A, it's a matter of objective general law, whether an offer is accepted or rejected, and B, in this particular context, it may well not matter very much, whichever way you analyse the position.
I mean, it might affect whether you're going to become the tenant of the property in Derby or not, but it's not going to affect whether the local authority has ceased to owe you any duty.
So, to deal with those 2 points, first of all, matter of objective law. The whole thrust of Part 7 is that decision-making is not for the court. As my lords and my lady know, the system of challenges by applicants is that for most decisions they can request a review under Section 202, various decisions. And that review is conducted under the auspices of the local authority, usually within the local authority, sometimes they contract it out, but it's a local authority review decision, and that review decision looks again at all the facts and the law and the circumstances. So that's a second bite at the cherry for the applicant. She has a wholesale reconsideration if she requests a review, but subsequently her right to challenge her on a point of law to the county court akin to judicial review.
Yep.
And there is numerous and Supreme Court level authority to the effect that none of these decisions are decisions that the court will take objectively. They are all evaluative decisions for the local authority, which once they come to court can only be challenged on a point of law. And so the answer to is refusal or acceptance an objective fact? Yes, it is an objective fact, but it's an objective fact for the local authority to take that decision on, and not for anybody else, not for a bystander, and more importantly, not for a subsequent court. So there can be, and we accept it's unusual. We accept the bulk of disputes are about suitability, but it's clear, both from the case from the case law and indeed from this case and so forth, that there can be disputes about whether or not somebody did actually refuse or accept an offer.
Well, can that be dealt with by the extension of time provision in section 202? Okay. So if there's a genuine dispute and the matter is raised with the local authority, they can extend the time.
But it's still...
It's all going to take place within a very short period of time. You get the offer. There's a short time scale set out by Parliament. The offer is either going to be accepted or rejected. If some hiatus occurs within that time frame, do you not apply to the local authority to extend time to review, say, well, unbeknownst to you and unbeknownst to us, all these various things occurred. And if the local authority didn't extend time, you won't have, you could judicially review that or either appeal it.
The route would be judicial review on that, yes.
Yeah.
That may be the route for getting the local authority to make a later decision, but it doesn't alter my point that at some point, post-offer, there might be facts that the applicant raises, or the local authority knows about. They may know there's a train strike on the day that you have to get to Derby. They found that out after the offer letter, so they know that you can't get there. And therefore, they have to come to a decision about whether you refused or accepted.
Why do they have to?
Because it's in the statutory scheme. Because the circumstances under which the duty cease is if the applicant, having been informed in writing of various things, accepts or refuses such an offer. I'll come to Lord Reed's point about whether it makes a difference in a moment. But they have to decide whether she has accepted or refused. That's an element of the circumstances under section 1937AA that somebody has to objectively determine have occurred before the duty ceases. And the difficulty, we say, is that the offer letter, it could anticipate that if you don't travel to Derby, we will deem that you refuse the offer and so forth. It could set that up as an anticipation, as a likely consequence, as a warning, but it cannot make a final decision because your failure to travel to Derby may not have been a refusal. It may not have been in your control, the derailed train, the train strike, and you were in hospital and so forth. We give various examples. So they do have to make a decision on the facts, which is an objective decision, but involves an evaluative judgment. And the two examples that are in the higher courts of where local authorities had to think about whether there was a refusal or acceptance, one is Nicolave and Redbridge, and the other one is Wandsworth and Young. And in both cases, Wandsworth and Young was slightly different, but Nicolave and Redbridge, the reviewing officer had decided that there had been a refusal, and the Court of Appeal said that that was not wrong in law. In terms of the extension of time point, we say that that wouldn't be the full answer. That is an answer to something happening late that you would want to draw the local authority's attention to, but your review is against the decision that the duty has ended, section 2021B, and that decision cannot have taken place at the date of the offer letter because, as I've said, and I'm in danger of flogging it to death, that the local authority can't make a decision about facts that have not yet occurred.
Just to take your example of somebody not being able to travel.
Yes.
And they're travelling with the intention of accepting. And by virtue of the fact they can't travel, they didn't accept. And is treated then as a refusal.
Yes.
Why can't they extend time and say, look, we wanted to accept? Why not deal with the matter as a matter of general law, as it were, by picking up the telephone and saying, well, yeah, I want to accept this offer?
Because there is no crystallised decision that she knows she's got to review. She doesn't know that because of her failure to get to Derby, for reasons beyond her control, the local authority have decided that she has refused. And we make the point because both the respondent and the second intervener respond to us on that if there was some sort of difficulty outside of her control, broadly they say, well, any reasonable local authority would, of course, not make the decision that she's refused, give her more time, and so forth. And we agree, any reasonable local authority would. But the difficulty is that if the decision is the decision of the 11th of June that she has refused, if she doesn't get to Derby, and then on the Monday, the 15th of June, she doesn't get to Derby for reasons beyond her control, it's hard to see how a local authority could then, and that happens automatically, it's hard to see how a reasonable local authority wanting to help could unravel those consequences. They would have to quash the decision of the 11th of June.
But isn't that whole problem created because you say there has to be this decision as to whether she's refused and accepted? If you treat the decision in the offer letter as being, this is what we are offering you, you can refuse it, you can accept it, whichever happens, our duty is now coming to an end, then she has 21 days in which to decide whether she wants to review that, and that presumably will be based on her assessment as to whether she's happy to move there. So in fact she has 21 days to decide whether to refuse or accept the offer, could travel up to Derby at her own convenience. It's only because you regard the 11th of June offer letter as setting a deadline for her to refuse or accept that this problem of the ambiguity of her conduct then is created, isn't it?
Well, we say our response is the response that provides for the clarity and avoids the problems. It's Waltham Forest that provide the deadline. They say in the offer, please meet the agent at 2 p.m. on the 15th of June at the address in Derby. I'm on page 225. The offer of accommodation cannot be held open for you for more than 24 hours, and the council will assume that you've refused the accommodation offered if you failed to attend. It's not very clear whether that means that the council will assume that you've refused it if you're not there by 2 o'clock on the Monday, or whether they'll assume that you've refused it if you're not there by 2 o'clock on the Tuesday. But they're setting up that deemed refusal. They're providing the deadline for acceptance or refusal. Or refusal. What you don't know, so you don't have 21 days to think about it, as it were. You have to do something by the Monday to indicate. That's the council's provision. And we say in our written case it's understandable why the council would set up that sort of deeming, because if they just left it open as to how you refused or accepted, then it's possible that applicants wouldn't be in touch. So one understands that. So they set up that timetable, And subsequent to the Monday, if events have happened that were beyond your control, the applicant simply doesn't know what the position is. In contrast, if we're right, and what the local authority has to do on the Tuesday morning is send a letter saying, you were not in Derby, therefore you have refused, you have a right to request a review of that under section 2021B. You know exactly, it's very quick, and both parties know exactly what the position is. They know that that letter tells you that the duty has ended as of that date, and that there are 21 days in which she can request a review, and if she doesn't after the 21 days, the local authority can be subject to the question about extending time, and there may be a good reason, but can be relatively confident that they can close their books on her, as it were, and she knows what the position is because she knows that the duty has ended. So we say that it's the lack of a subsequent decision after the offer letter that causes all of these problems and confusion. We go so far as to call it chaotic at one point. Whereas if there is simply a decision, which may or may not be right, Lord Reed's point about it doesn't have to be the right decision. It may. Waltham Forest said you weren't there, you refused it, and she then has a point that the train derailed. I didn't refuse it, and that's my request for review. The decision that the duty has ended may or may not be right, but she knows what she's challenging. She knows she can request a review of that decision, and she knows what her case, what is decided against her and what her case in response is. The problem with all of that being in the offer letter is that, as I say, the offer letter can't anticipate events that have not yet happened. It can give suggestions, it can give warnings, it can give anticipation, but it can't make final decisions as to events that have not yet happened. And so my client, others like her, who are of course vulnerable people being housed under homelessness duties, are faced with an unclear situation about what they do. And this offer letter does not provide for any of the scenarios that we've been discussing about what might happen if you're unable to get to Derby. It doesn't set that out in detail. I need to deal with, I think it was Lord Reed's point. Sorry.
I do apologise. Previously there was a requirement of notification.
Yes.
What were they notifying? Were they notifying a decision?
No. Well, they weren't notifying the full decision that we've been talking about. They were, it's page 437.
But I was just wondering what, in your scenario, they would also have to be notifying a decision that the offer was accepted or refused, presumably.
Well, if we look at 437,
yeah.
Subsection 7 towards the bottom, there are two elements to it, all of which have subsequently been incorporated into section 193 as it now is. And this was the original enactment, and it was amended in 2002. The local housing authority shall also cease to be subject to the duty under this section if A, the applicant, having been informed of the possible consequence of refusal, refuses an offer under Part 6, and B, the authority is satisfied that the accommodation was suitable for him and that it was reasonable for him to accept it, and notify him accordingly within 21 days of the refusal. Now, there isn't any judicial decisions on exactly what that means, but we read that as the original enactment was that there is a notification of the decision that the accommodation was suitable and reasonable for the person to accept, i.e., notification of the elements in B, rather than notification of the elements in the whole of the elements.
But it also provides that the duty only ceases if there's a refusal.
Yes, yes, because this is a long time ago and deals with offers under Part 6 and does not deal with private rented sector offers, which are subsequently amended by the Localism Act. So it only deals with refusal. It was indeed enacted at a time when the Section 193 duty was also time limited to a period of 2 years. So you didn't necessarily, the idea was that during those 2 years you might get your Part 6 offer, an offer of social housing, or you might not, and the duty would end. That was changed in 2002 so that the duty remained open until one of the events in section 193 occurred, normally an offer of Part 6 accommodation, and then gradually between 2002 and 2012 the consequences of a offer of an assured short-hold tenancy and acceptance or refuse it was brought in by various amendments. So it's changed considerably. But we say it's not...
Sorry.
I'm sorry.
Doesn't the local authority have to decide that there has been a refusal?
Well, we say yes, and they always did.
Yes.
That's our case.
But that provision has been removed. That provision incorporates the authority telling the applicant that there has been a refusal.
Well,
deciding that there has been a refusal.
We don't know that. We say that's not entirely clear from A and B. There hasn't been, as I say, any judicial interpretation of it. But we say that the reading as it originally enacted looks as though the notification duty was about the elements of B, not the elements of A and B.
I'm sorry, where are you getting the notification duty from?
Page 437.
Yes.
Subsection.
The original version, is it?
This is the original version between 96 and 2002.
Oh, and it's the and notify him accordingly.
And notify him accordingly.
Right, okay.
We say that if and notify him accordingly was intended to refer to the elements of A and B, it would have been a C. But as it is, it's... as I say, there hasn't been any judicial interpretation of that as it was then, and unlikely to be now. But it's not as straightforward as to say there used to be a provision under subsection 7 that there had to be notification of a decision that the offer has been refused and that notification has been removed. We say that is not apparent from the original wording.
So your case really is that if you look at now 7AA, A and B,
yes,
there has to be a decision that it's either A or B.
Yes, yes. And that takes me to why does it matter?
Yes.
And it matters because the consequences are so severe for the homeless applicant, because clearly if she accepts, then she would move in and she will no longer be homeless. And if she refuses, the duty ends, the temporary accommodation that she's been provided for under the duty ends. And at some point, on the facts of this case, it was very slow, partly because of COVID. It took some 3 years, in fact longer because she stayed in temporary accommodation. But at some point, temporary accommodation would end, and because that duty had ended, she's potentially homeless. She does have the opportunity of a new application. That's further down in section 193, subsection 9, but she won't necessarily, on a new application, have the full duty again. So the consequences for her are extremely severe. She's potentially facing literal homelessness without necessarily a safety net from the local authority.
It seems completely unrealistic. I mean, the person who knows whether the offer has been accepted or refused is the appellant. There may be the odd case where it's unclear, and there may be a dispute about it, which may have to be resolved. But one can hardly envisage Parliament imposing a duty on the local authority in every case to tell the appellant that she has accepted or refused the offer.
So first, she may not know whether she's accepted or refused it. She may get to Derby at 2:30. She may be very confused. These conditions are set up. Again, bearing in mind that we have vulnerable people here, some of whom, including my client, English is not her first language. She's helped by her children and so forth. So she doesn't necessarily know. That's the first point. The second point is that under Part 7, it's not for applicants to make decisions. It is for local authorities.
Yes, I'm not. This isn't to do with decisions.
No.
I'm querying the idea that local authority is under a general duty to notify appellants of things that appellants can be expected to know themselves. Particularly when it doesn't signify, it has no, whether it is accepted or refused, has no bearing on whether the duty continues to exist.
It has no bearing under 7AA. It has a bearing under 7, which is the offer of a Part 6 accommodation, which is about refusal. And we were looking at the original enactment of that earlier, with a few moments ago, with notification, where the acceptance is also, the possibility of acceptance and the duty coming to an end is further up in section 1936C. And that leads me to my other point. And I don't necessarily want to move away from the why does it matter point. But my other point is this, that if we're right, and the principle of statutory interpretation means that the words, the local authority shall cease to be subject to the duty under this section if the applicant does various things, then that applies to subsection 6, subsection 7, and subsections 7AA. And if one looks at subsection 6, it's very hard to see how certainly a number of those circumstances could result in the duty having come to an end without the local authority having to make a decision about it.
Yes, I mean, I think that's, if I may say so, a reason why one can't just rely on this cessation as being, nobody actually has to take a decision, because as I understand it, being eligible for assistance turns on your immigration status.
It does.
Yes.
It
so
does.
There may be a decision taken by someone in the Home Office that affects your, I don't know whether this is the case, but I'm positing if this is a possible scenario, there may be a decision taken by someone in the Home Office that affects whether an applicant is eligible for assistance, that neither the applicant nor the housing authority yet knows about.
Yes.
And you're saying it can't be that the duty just then evaporates.
Yes.
Because then the Section 202 review process doesn't work.
Possible to know how it kicks in, yes.
It's possible to know how it kicks in.
Yes.
But even if one says there has to be some kind of decision and some kind of notification of that, otherwise some of these in subsection 6 don't work, that still leaves the question whether the offer letter is that decision and is the notification of that decision.
And my answer to that is as I say, I think I've
no, but it's
said it very time. My answer to that is that the problem with the offer letter being that decision is we say conceptually very hard to understand how a letter of the 11th of June can make a decision about events that happen after the 11th of June.
Okay, can I just come back to the example just given about eligibility for assistance? It perhaps illustrates the distinction between whether in law there is a duty and whether in fact there has been a decision. We're told by subsection 6 of 193 that the housing authority shall cease to be subject to the duty if the applicant ceases to be eligible.
Yes.
Okay, so that's a proposition of law. Under 202(1)(a), the applicant has the right to request a review of a decision of a local housing authority as to his eligibility for assistance.
Yes.
So what one imagines happens is the housing authority will decide you're not eligible for assistance because we owe you no duty under 193 because you are no longer eligible for assistance. Well, it may be right or wrong about that. If they're right about it, the duty has in law ceased. But the decision, whether they're right or wrong, there will be a decision capable of challenge under 2021A.
Well, yes, my lord, but there still has to be a decision.
Yes, I'm not.
And if there has
that.
to be a decision for 6A,
what I'm disputing is the proposition that the duty cannot cease unless a decision has been taken. And what I'm suggesting is that by operation of the statute, the duty ceases to exist in law the moment the person ceases to be eligible for assistance. But that's quite a separate question from whether a decision has been taken by the housing authority. And obviously, if a person has applied for housing as a homeless person, and the housing authority is going to decline to assist them because they're not eligible, then it has to take a decision to that effect, which will be capable of challenge.
So we're in a slightly more nuanced situation there, because this is about someone who ceases to be eligible, who was originally owed the Section 193 duty. So it's an applicant who had applied, had an original decision that she was eligible for assistance because those were her immigration status at the time, and then and the Section 193 duty is owed, and then for whatever reason her status changes. And then we come to Section 193(6)A. Now, the disputes about eligibility can sometimes be very simple because the consequences of a decision on an immigration status can put you on one side or a line or another, and there isn't much dispute about it. They can also be a very complex application of facts to law, and they're not necessarily a decision made by the Home Office. And there are numerous decisions until quite recently that dealt with the legal status of European Union nationals, which was not a subject of Home Office decision-making, but was the subject of local authority decision-making. So it's very clear that any decision as to eligibility, whether eligibility originally or subsequent change of status that might lead to the loss of the duty, still has to be a decision by the local authority, albeit they may be very informed by a Home Office decision, or they may not be because the Home Office might not have been decision-making.
Well, sorry, just can I ask you on that? I mean, suppose the Home Office notifies the local housing authority, this person's status is going to change 1 week from today and they will cease to be eligible. And the local housing authority writes to the person and says, our duty to you under Section 193 will come to an end 1 week from today because you will cease to be eligible. Would that not be a decision of a housing authority as to his eligibility for assistance?
I take the point. The point being that suggests that the duty is what's been referred to, the decision is being what's referred to as a prospective decision rather than my point that there are subsequent events. I see that point.
Well, and forgive me, what's the answer?
I'm sorry.
It seems that the language of Section 202(1)A would be apt to cover the sort of situation that I was just putting to you.
The answer is either I dispute that on the facts as of the date of the letter you've just sent me, or within this week something is going to change. Yes. And if that's the case, the local authority would have to make a separate decision.
Right, but if you're disputing the facts, so if you want to say, well, the Home Office might have told you this, but actually, as a matter of proper understanding of the law as it applies to my facts, I won't cease to be eligible at that time. Well, why couldn't you seek a review of the decision, admittedly a prospective decision, but clearly a decision, that the local housing authority has made that you will cease to be eligible?
You could, because that's...
Sorry, you could seek a review of that.
You could, because the local authority is not making a decision about what's going to happen in that intervening week. They've made a decision.
No, but they've made a decision what's going to happen at the end of that week.
And indeed, thinking about it, and
That's the whole point of my question, is they've
Yes.
made a decision what's going to happen at the end of that week. You want to say, you've misunderstood how the law should apply to my case.
Yes.
In fact, I will continue to be eligible.
Yes. Yes.
So you have an issue, a dispute that is crystallised between the parties, admittedly before you get to the end of the week, but the dispute, the ambit of the dispute is known.
Because
Why couldn't you seek a review?
Because it has crystallised, so you can. It's very hard to think of a set of circumstances
Right.
where the local authority says on the Monday, as of the Wednesday, your status will change, and therefore our duty will cease. They would be much more likely to say on the Wednesday, on the Monday the Home Office told us that your status has changed, and therefore we're notifying you of a decision that you have ceased to be eligible.
Sorry, but my example was intended to make it prospective, where the Home Office has said there's going to be a change of the regulations in this area, which is going to come in a week from now. And the local housing authority, with notice of that change in the law, looks at the circumstances of the individual and says, well, when this new law comes in, your eligibility status will cease. And you need to know that we will no longer accept that we owe you the Section 193 duty when that happens. But the individual wants to say, no, that you've misunderstood the position. I will still be eligible.
I'll still fall within the regulations, yes.
And so my question then is, it seems on the face of it that is a decision of a local housing authority as to his eligibility for assistance, in respect of which a review could be sought.
Yes.
You're saying yes, they could seek a review.
Still, forgive me, thinking it through a little bit.
No, that's all right.
Because the local authority is not saying that you will cease to be eligible because of something that might happen during the week. They're saying that you will cease to be eligible because the regulations are changing within this week. Something hard. It's hard. It's a hard fact.
Okay.
It's a matter of law. They are not postulating a decision that your circumstances, your factual circumstances, are changing during the week. And so, in that respect, they could take that decision, but as soon as you write back and you say, actually, I don't fit in, you've misinterpreted the regulations as the change in regulations as applies to me. That's a new fact, suggesting that they were wrong in their original decision. The question is
precisely.
whether that should only be
so my question is,
yes.
the day after the letter is received, you, the individual, know that, or think that the local housing authority has misunderstood the way these new regulations are going to bear upon their position. And they've clearly indicated that they're going to, what they are deciding shall happen as regards the eligibility for assistance. So I'm asking you again, would the individual have the right to request a review of the decision under Section 202(1)A in that situation? Or
wait for another decision is...
Well, don't complicate it, just answer, if you would, my question is posed.
Clearly she would, and she'd be doing it on the basis of new information. She says, these are my circumstances, this is why I don't fit within the change in the regulations.
Right.
But the reason why that is different to the point about refusal or acceptance in 7AA or 7 is because her circumstance, her legal circumstances may be changing, but her factual circumstances haven't changed. Whereas the refusal or acceptance is something that, as my Lord Reid said, the applicant has to do, but there could still be a dispute about it. So it is something that has not yet crystallised, whereas my Lord's point about eligibility would have crystallised.
Yes, thank you.
Right, but you say that even though one might read 1936A as the duty just evaporating without anybody taking a decision, that can't be the correct reading of it, because there has to be a decision as to eligibility as to which is capable of review under 2021A.
Yes.
And one might add,
yes.
and they have to be notified
yes.
of it. So the
Either A or B it would fall within.
21-day
yes.
period can
yes.
start.
Yes.
6 is a truism. I mean, obviously, there can't be a duty owed to somebody who is not eligible for assistance.
But there still might be a dispute about it. Not about whether the duty is owed, but whether somebody is eligible.
Yes, you make a decision as to whether the person is eligible.
Yes.
And as soon as that decision is made that the person is not eligible, the duty ceases.
Yes.
Well, that's what we're debating, whether it evaporates, but there is still some obligation to make a decision and notify that decision,
yes.
or whether the duty ceases on the eligibility ceasing.
6 isn't concerned with, it has nothing to do with decisions. This is to do with whether there is a duty or not. This is law. The local authority shall cease to be subject to the duty if A, B, C, D, or A, B, C, 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 or D.
But within any of those, and I draw attention to B and D, where the ceases to be subject to the duty if the applicant becomes homeless intentionally from the accommodation made available, or otherwise voluntarily ceases to occupy as his only or principal home. There's a number of factual decisions to be made.
Well, I know.
The legal.
Of course, I understand perfectly well that whether or not somebody has become homeless intentionally has been litigated hundreds, if not thousands, of times.
Absolutely.
But the reason it's litigated is because if you have become homeless intentionally, then the local authority doesn't owe you any duty.
Or if they previously did it else.
That's a rule of law.
Yes.
It doesn't depend on any notification being given by anyone to anybody else.
So, yes, but what the effect happens, but the local authority has to, nobody else is making a decision about whether or not the applicant has become homeless intentionally. So for that circumstance to apply, somebody has to decide whether the set of facts, the person's left their accommodation for some time and so forth without a reason, whether the set of facts applying the legal test of intentional homelessness amounts to becoming homeless intentionally. They have to make that decision because there isn't any other decision maker within the statute. So the
think we're like two bridges that were across it, where our paths are not crossing.
I'm so sorry.
Well, I think
you're addressing a point that seems to be beside the point.
Right. The point I'm trying to get across, which perhaps is a point more for Mr. Grundy than for you, is that at the moment I don't understand how 2021A and 2023 can work, given, as you say, that the idea is that there should not be judicial reviews of all these decisions or automatic cessations, but it's supposed to be review and then by the local authority and then appeal only on a house of law. How that's supposed to work if the duty just evaporates on the happening of certain events outside the control, some of them of either the local housing authority or the applicant, and sometimes even outside the knowledge of them, it looks like opening up a whole range of circumstances which don't fall into 202, which are intended to fall into.
And that's our submission. If the duty evaporates or automatically ceases, how does one operate the review mechanism?
Well, the way it operates,
but I do want to come back to the bridges passing.
The way it operates there is no problem at all about the way it operates. 193 is setting out the legal structure,
yes,
what the legal rules are,
yes,
that govern the duties of local authorities and eligibility for assistance. Now, the local authority has to operate that.
yes,
It has to take decisions.
yes,
And any decision it takes in relation to these legal rules and the facts of the particular cases is going to be capable of review under 202 if it falls within the scope of 202, as almost always it will. And if by some chance it doesn't, then it will be capable of judicial review.
yes. But, so I'm concerned about our bridges passing each other, my lord,
right.
And what I'm saying that doesn't fall
I think, if I may say so, well, certainly speaking for myself, the difficulty was in the idea that the duty evaporates.
Yes.
The duty is either exists or doesn't, as set out in a table of preconditions which determine is there a duty or not a duty.
Yes.
Those exist as objective facts. You might have argument about whether objective facts exist or don't exist,
yes,
which will determine whether the duty exists or not, but the nature of whether the duty is there or not is a purely objective legal matter.
Yeah, it operates in the same way as the law of contract or the law of tort. You have a body of legal rules, which we have in 193, and then you have human beings who operate those rules and apply them to factual situations, and there may be disputes, in which case the disputes go to dispute resolution mechanisms like courts and tribunals.
So they're trying to recognise what is the true underlying legal position. They may misrecognise it.
Yes.
That happens all the time. What do you do? And the first people that are trying to recognise these things, the application of the law, is the local housing authority.
Yes.
What do you do if they've got it wrong, in your view, as the individual? You look to see whether you can review their decision under Section 202.
yes,
And then, subject to a few marginal cases, as my Lord says, if you can find something that can't be fitted within Section 202, then you might have to go for judicial review. But since Section 202 is intended to be the primary mechanism for testing whether the local housing authority has got it right or not, one might think you'd interpret that actually quite expansively to make sure that people actually have the rights Parliament intends them to have to challenge what the local housing authority does. If for some reason you can't, even on an expansive interpretation, find a slot, then judicial review is a genuine fallback. It always is, if someone has misconstrued in public law what their legal duties are.
yes.
But none of this, at the moment, I'm struggling to see how this helps you. Because we have the table in Section 193 of a whole series of predicates for the existence of duties or not. We happen to be concerned with the predicate in subsection capital A, capital B.
AA, yes.
AA, forgive me, yes. AA. About whether someone has accepted an offer or has refused an offer. And I don't want us to completely lose sight of the fact that whichever way they jump under that situation, the duty is going to come to an end. So usually it won't matter which way they jump for the purposes of this regime. But the local housing authority is going to have to make a practical decision. Are they allowed to stay in a particular property? Just as they will have to make a practical decision where there may be an argument about eligibility for assistance. Can they stay in this property? That's how these matters usually come to a head. Because the local housing authority, in order to decide can someone stay in this property or not, is deciding, well, do they have a right under Section 193, or do we have to look somewhere else. So that's all, if you like, the critical decision-making point for both the local housing authority and the individual. Am I going to be allowed to stay in this property? Now, when one's looking at our situation, it's true that the local authority has indicated in advance what is to happen, but it's very clear that either the offer of the private sector property is accepted, in which case the duty comes to an end because they're going to go to the private sector property, or if they refuse it and it was a suitable offer, then the local housing authority is going to take the position that their duty has come to an end. And that position reflects a decision by the local housing authority. How shall we treat this individual? And it is known when the offer letter of June 2020, 11th of June 2020, was sent. So, I mean, at the moment, what I'm struggling with is why, if there's to be a dispute about whether they could make such an offer, the relevant facts sufficient for that dispute to be ventilated via a review aren't known at that particular point in time. Yes. And therefore, why Section 202, subsection 1b, on its ordinary wording, does not apply to cover that situation, yes. Which is what I thought it was what we were debating.
Yes. I'm grateful for that explanation.
I'm sorry, it went on so long.
So, my Lord started with the problem is the idea that the duty evaporates.
Yeah.
And we entirely agree, that's our case.
Sorry, that it does evaporate?
That it doesn't,
oh, right.
That it shouldn't do. It's the respondent's case in response to our ground one, and it was the Court of Appeal's decision that the duty automatically ceases. And so one has the offer letter. I'll come to the point about whether everything's contained in the offer letter in a moment. But it's the respondent's case that there's an offer letter, there are subsequent events, and the duty automatically ceases. Now, that's not my case.
No, but forgive me. Here I do think we may be shit-tossing in the night, because yes. I think you're using the word evaporates in a different sense from what I was understanding here. So you're now using the word evaporate to mean comes to an end through operation of law. I thought previously you were using evaporate to mean, although there is a duty which exists in law, it evaporates because the local authority hasn't recognised it. And that's a different sense.
I don't think I was. No,
all right, well, that's my fault if I've misunderstood.
I'm sorry,
that's the sense in which I was using evaporates, that you seem to be saying, well, there may be, well, I think you were saying that there may be a whole set of duties which exist by operation of objective law as set out in Section 193, and there are a whole different set of predicates as to whether a duty exists or not. But those are all objective features of the law. They either exist or they don't. Those, but there is a requirement for human beings, in the first instance the local authority officials, to recognise whether there is an objective duty or not.
Yes.
Now, the objective duties in some circumstances do, on the language used in Section 193, come to an end by operation of law. There may be factual disputes about whether that has happened.
To the legal position.
But
yes.
the legal criteria are set out in Section 193, which enables you to tell whether a duty exists or not.
Yes.
Separately, people have to do the recognising of whether the duty exists, which is when the local authority decision makers decide, are you still eligible? They might make a mistake about that. They're doing their best to look at your situation and decide, is the duty owed to you or not?
Yes. And
if they get that wrong, or you think they've got it wrong and you want to challenge it, then you have a review mechanism, which is Section 202.
Yeah.
Now, in the first sense, well, in the sense of evaporate that you were using it just now, you seem to be saying that a duty cannot come to an end through operation of law. Using evaporate. Right, okay.
I'm sorry, my lord.
Well, no. But I thought that we were debating a different sense of evaporate, which is that if a duty is not recognised, it doesn't exist. I.e., it isn't recognised by the humans. They've made a mistake, but somehow the duty doesn't exist because they've made a mistake. I'm
thinking about that formulation. And to a certain extent, evaporate has been a word we've used this morning and hasn't...
No, well, quite. That's why I thought that I'd better...
Respondent's case is automatic cessation.
Yes.
Following the offer letter.
Yes.
And we say, and my lord has just put it perfectly, we say that in respect of all the circumstances under which the local housing authority ceases to be subject to the duty, because it is a question of law as applied to the relevant facts at the time, there has to be a decision maker, and the only decision maker can be the local authority, the housing officer.
Right.
My lord just...
So that way of putting it does seem to involve, is this not right? You writing in an additional condition for the existence or non-existence of the duty, namely that if the housing authority is maintaining that a duty which once existed has now ceased,
yes,
that they have to have given notice that, in their view, it has now ceased.
We say two things have to happen.
Well, just so maybe I'm confusing myself, but I think that I'm now understanding what you're saying. If you could look at subsection 7AA, the one that we're concerned with, which I think is page 465. So it seems to say, one might think in relatively clear language, the authority shall cease to be subject to the duty under this section if the applicant, having been informed of the matters mentioned in 7AB, so let's just focus on that you're having an offer of this particular character made to you, accepts a private rented sector offer or refuses such an offer. So whether you accept or you refuse, the duty comes to an end. But as I'm now understanding what you're saying, you're saying, oh no, it doesn't come to an end then. It only comes to an end if you add in effect, a little c, and the local housing authority notifies the individual of its opinion that that duty has come to an end. So is that a fair way of putting your case?
We break down the case a little because we say all of that, except when my lord comes to little c, we say that the duty does not end until the local authority has decided, because somebody has to decide, that this set of circumstances is made out. And then, as it were, little d, a separate question about whether that decision has to be notified, and that's in our ground 3.
And does the decision have to be correct?
It doesn't have to be correct, no.
So the duty can cease even if the decision is incorrect?
Well, no, I don't.
Well, it's difficult. Clearly the duty might be inadvertently incorrect because they've got the facts wrong and so forth, and the remedy for that is review. But my primary concern is to say that there is a decision by a human being, a housing officer, and that the elements of the relevant subsection are made out. Insofar as whether or not the duty is correct, it may well be incorrect, and that's the purpose of the review. But there is a concern which this case exemplifies, that if the local authority knows that as a matter of law its decision was incorrect, and so here in May 2023, and I was asked right at the beginning, was May 2023 the confirmatory decision, if the local authority at that point knows as a matter of law that its original offer was not right in law, then it cannot be right as a matter of public administration or law that a local authority could then take a decision that the elements of section 193(7a) have been complied with, knowing if they then do, that in fact they hadn't complied with it, their offer letter was defective and so forth. That is problematic, I say, and it cannot be right that the public authority, as the decision maker, as the body between the two parties that has all the responsibilities of making decisions, but also is not in the same position as an applicant. Their local authority is advised, informed and so forth. It cannot be right that a local authority should knowingly rely on an incorrect decision.
Can you help us? You say that 7AA, as set out is in the statute, is not the whole story. The authority doesn't cease to be subject to the duty merely if A and B are met. There is something more required. Can you tell us what exactly it is more that is required?
Somebody, a person in the local authority, has to make a decision about whether 7AA, A or B has occurred. And there's two reasons for that.
So just pausing there. So we can add in a little c. The authority has made a decision whether A or B has occurred.
And indeed, the matter, if when one reads 7AA through to 7AC, the other matters there, yes. And give me one moment. We have to say this, don't we, that you have to read it.
So, sorry, the authority has made a decision whether A or B has occurred and that, and what? Was it that the applicant has been informed of the matters mentioned?
So that's a separate point, and I'm not. I will come to that. But we say that that the only way in which 193 can operate is that somebody has to make a decision as to which of these matters set out in 7AA to 7AC inclusive have occurred.
So is it simply C, the authority has made a decision whether A or B has occurred?
Yes, they have to make a decision. And that was the decision of the Deputy High Court judge, which the Court of Appeal overturned. But we say, we acknowledge it's not in the statute, and we acknowledge that elsewhere in Part 7, generally in the more modern amendments, then such a decision-making and notification duty is written into the sections. We acknowledge that.
No, you just mentioned notification. So does the authority also, in order for the duty to cease, does the decision have to be notified?
We say it does, and that's our ground 3.
Right, so the authority has made a decision, etc. D, the authority has notified the applicant of that decision.
Of the decision in little c that we've just written in, yes.
And you say you have to imply that in so that the review process works?
Yes. So I say that, one, it's impossible to know how the review process works if you don't have notification. You don't know when you don't know, originally you don't know that a decision was made, and the review process itself starts the time running from notification to the applicant. That is section 202 subsection 3. So I say that, and I also then refer to the common law principles in Anu Frieva and in D4 of the two authorities that we've put before you.
Because it's notable that section 2023 does not make the time run from the cessation of the duty.
No.
Because that then really would leave you
Yes.
in very difficult decision.
Yes.
It's very difficult.
Yes, yes. It's very noticeable that that is the case. So the section 2023 clearly allows for an applicant to say, this is the date, I received this on the 1st of May, and today is the 20th of May. Sometimes there are disputes about that.
And it may turn out that actually, according to Mr. Grundy, the duty ceased some time ago, unbeknownst to everybody. A
decision that the duty ceased, we would say, took place some time ago.
No, I'm not. I'm deliberately not saying.
I'm sorry.
I'm saying that it may have. Yes, the decision is that the duty has ceased.
I mean, for example, the authority might discover long after the event that the applicant was ineligible, and they didn't know that at the time. So as a matter of law, the applicant was never owed a duty. But if the housing authority's view about eligibility is correct, then no duty was ever owed. But the time to challenge the decision won't begin to run until the housing authority has actually made a decision that the person is ineligible.
That's a different set of facts which an authority called Porteous and West Dorset deals with. That if the local authority, when deciding that the Section 193 duty was owed, did so under a mistake of fact circumstances at that time, then the local authority can withdraw that earlier, what's called a Section 184 decision. So it wouldn't quite come into 1936A does deal with a change of circumstances.
I mean, the point is that because 193 is a legal structure,
yes,
and 202 is to do with review of decisions,
yes,
a situation in law can come about before anyone knows about it in fact. And it's when something is done about it in fact that a decision is triggered which is capable of challenge. And so that's when time begins to run. And
that's why we say there does need to be the structure of Section 193 only works if one reads in that the local authority makes a decision. My Lord reads little c, and then also, for the reasons we've just been discussing, reads in that decision should be notified. We say that has to be a matter of statutory interpretation and public law. We also make the point that, of course, for an applicant to request a review of a decision about whether she ceased to be eligible or about whether the duty has ended for other reasons, she has to know in bare form, but the case she is meeting, the matters that were decided against her, and she can't know that without a notification that contains very shortly.
In our case, she'll know fine what she's got to challenge, won't she, from the letter in June 2020, because they said.
So the outstanding question that my Lord put, and I haven't come back to and do need to deal with, is whether the offer letter of the 11th of June is sufficient as a decision. And that's our ground too. And we say it's not because of the point that it is anticipating certain events in the future. And insofar as it's been characterised as a prospective decision, then we would say that, which is, I mean, that's a characterisation, it's not in the Act, then we would say prospective doesn't mean final, it means anticipatory. One talks about a prospective purchaser of a house, a prospective tenant. Prospective is contingent on various events happening, and does not mean that there'll be a subsequent rubber stamp or automatic. It does mean that a decision maker, in this case the local authority, still has to make a decision about whether or not those future events, post-offer events, have happened.
There's just another question is, if it's possible, as is being posited, for there to be a cessation of duty without people knowing about it, would the housing authority be in breach of some other duties somewhere else in the person who is in fact not eligible still occupying housing stock belonging to the local housing authority? Because I don't think we could have a situation in which the local authority is actually unlawfully housing someone, even though they are not eligible, for instance. It may be that's not a.
I see my lady's point. Off the top of my head, probably not, okay, because the rules around prohibition on right to rent on the basis of certain immigration status, which is what I think my lady is thinking about, apply to private rented sector rather than to social sector. I'd have to check that. But
there's no sort of general provision that says local authorities must only provide housing to people to whom they owe a duty to provide housing.
No.
Okay.
No. And indeed, the accommodation that is being provided under Section 193 is not necessarily provided is the wrong word. The word in the Act is secured, and that's a better word because sometimes people are in council's own stock, but far more frequently they're either in very temporary accommodation, such as hostels and hotels and so forth, or they are in accommodation that is provided often under an assured short-hold tenancy, but still it's temporary accommodation by a private landlord, which is what, in fact, my client was in the temporary accommodation she was being provided. So it's the local authority is rarely providing the Section 193.
No, securing is that's not
I don't think, I will think over the lunchtime about whether there could be such a scenario, but off the top of my head, I think not. So, I mean, in terms of, it comes back to our ground two, whether the letter of the 11th of June operates as a, as I say, what it's been characterised by the Respondent and the Court of Appeal as a prospective decision. I've made the point, somewhat to death, that we say you cannot have a decision which is crystallised in respect of which there is a right to request a review under Section 2021B, that the duty has ended when the events haven't yet occurred. My lords and my lady have that point. We have referred in our written case to the public law principle that judicial review doesn't typically lie against decisions that are merely provisional or contingent. We've given you the authorities of Burkitt and Yalland, and we say that the offer letter would be such a decision. It would be provisional or contingent on the various events that the offer letter sets out, and therefore the offer letter in itself cannot operate as a decision that the duty once owed is no longer owed, which would give you the right to request a review under Section 2021B. And we draw attention to the practical issue. If the offer letter is operating that decision that the duty once owed is no longer owed, and if the reason why the applicant then wants to request a review of the duty, of the decision that the duty once owed is no longer owed, is a result of various events that happen after the offer letter is sent to her, again, whether she was able to refuse, whether she received the offer letter, and so forth, whether there were matters relating to suitability that were not known to anybody at the time of the offer letter, we say that there are not only conceptual and legal problems about her being able to raise that in a review against an earlier decision before these matters have happened, but we also say that there is a problem with her knowing what the case against her is, the case she has to respond to in the request to review, and we say that there is a problem with when time might start to run. So if, for example, she's unable to get to Derby on Monday the 15th of June, and her right to request a review arises from the decision in the offer letter, but the matter that she wants to bring to the local authority's attention is something that has happened on Monday the 15th of June. Does the 21 days run from the offer letter, or does it run from the Monday? It's not at all clear. My Lord said that, well, the answer to that is a request for an extension of time if the subsequent events were after 21 days, but that's a very discretionary decision by the local authority. And we say again that in order to resolve those problems, the resolution that is right in law and as a matter of statutory interpretation is that, yes, there should be an offer letter, and that is a decision as to the suitability on the facts known to the local authority at the time of the offer letter, but that itself is not sufficient as a decision that the duty once owed is no longer owed, because it causes those problems, and those problems are resolved, we say, by the simple solution that there has to be a second decision, a decision that the duty has ended. You didn't go to Derby.
I'm not sure how that solves the problem. Suppose the house in Derby is actually lovely and she would be very happy to go there. She wants to go and see it, though, before she decides whether to accept or refuse it. But she can't get there on the 15th for one of the reasons that you say. How does there having to be a decision after the offer letter remedy that difficult decision, that difficult scenario?
Because she knows, say the decision is she receives on the Tuesday or the Wednesday, she knows that the local authority has now made a decision that you refused it, because that's what they said they were assuming that they would do. She knows that because that's a decision, and therefore she knows, one, that if she wants to that she wants to challenge that, she had wanted to accept it, she wasn't able to get, she can now request a review of that, and she knows she has 21 days to do it from that decision if it's given to her on the Tuesday. Whereas if, on my lady's scenario, that is exactly what happens, and she wants to go to Derby, but she can't do it on the Monday, she doesn't know, she knows from the offer letter the previous Thursday that she can request a review of the suitability. This offer letter, I should say, it's something that could be resolved by this court's decision in this case, but this offer letter did not say you have a right to request a review of the suitability, and you also have the right to request a review of the decision that the duty has ended. But if one supposes that the offer letter did say that, so that it was clear, it's still very hard to know on the Monday or the Tuesday what case she thinks she's meeting, because she knows that it wasn't her fault she couldn't get to Derby. And it's also very hard to know for her how long she has in which to request a review. Does the 21 days start from the date of the offer letter, or does it start from the events that led to her not being able to comply with the assumed conditions that are set up?
Suppose the reason why the local health authority has said you've got to go up on the 15th is because that is the window of opportunity that the landlord has set. So it's not available after that. Can she challenge under 202(1)(b) the decision and ask for a review of the cessation of her duty, of the duty, on the basis that they acted unreasonably in not allowing her more time to go and see it? Is that? No. There's extensive case law on the basis of that a local authority is not required to keep offers open. So
And that's one of the reasons why I keep coming back to this point about how refusal or acceptance is a binary concept in section 193, and we're saying that there may be events that don't amount to either refusal or acceptance, and that unless there is a decision notified to her that says you have refused, she doesn't know how to answer it, because on all the circumstances that we're looking at, we're talking about the grey areas where she wanted to accept but couldn't get there, or whatever it happens to be. But there is clear case, so a local authority is entitled to continue with its assumption that they set out in the offer letter, that if you're not there, we've refused, and they are entitled to say that there was a window because the landlord would have relet it and so forth otherwise. And the only way in which she can challenge that is not about whether or not the local authority was acting reasonably, because that's not a decision that falls within section 193, and it's not a decision for which there's a right of review under section 202. The only way in which she can challenge the local authority's assumption that you have refused when in fact you haven't is to be able to request a review of the decision that you've refused. Sorry, that last bit came out badly, but she cannot, under the reviews and the reviews system, make representations that a local authority should give her more time, act reasonably, and so forth. And that's part of the point that we develop in the written case, that if there is automatic cessation or the concept of a prospective decision, or however one wants to word it, in the offer letter, that the subsequent decision-making by a local authority that the applicant might ask the local authority to make, which might be utterly reasonable, can I extend time and so forth. It's very hard to see how those requests fall into the concept of automatic cessation or prospective decision. Whereas if there has to be a subsequent decision, as we argue, and indeed notified to her, then she can make the point that she didn't actually refuse, and she tried to contact the local authority and ask for further time to accept it and so forth. And that leads to a reviewing officer having to decide that. And in those circumstances, the reviewing officer may well decide that she didn't refuse, therefore the elements were not made out, therefore the duty continues. She continues in temporary accommodation, and one would expect either the accommodation is offered to her again, or if it's gone, there has to be new accommodation. So we do say that all the problems that we have been talking about are resolved by the simple solution of there being a subsequent decision on events that happen after the offer letter, which allows her to...
then gives you the opportunity to say, I didn't either refuse or accept because the conditions that you imposed, albeit they may have been imposed on you by the landlord,
Yes.
Were not reasonable in some way.
It's not so much whether they were reasonable, but I couldn't comply with them because these events...
Or I had a good excuse.
I tried to comply with them, I had a good excuse, and therefore I didn't refuse, that's right. And so that's where... that's how you would raise that point. You wouldn't be able to raise it within the systems of decisions and reviews in terms of asking the local authority to behave in a certain way and behave reasonably. There isn't a process for that. My lords and my ladies, I'm very aware of the time. Can I just draw your attention to 2 or 3 points, unless there's any other matter that... No, thank you. The second intervener makes a point about settled practice in relation to statutory interpretation. I've not addressed my lords and my lady on the principles of statutory interpretation. They're in the written case.
You can take it, we're very familiar with
my lords and my lady are far more expert on it than I am. But just on the settled practice point, and they rely on the...
Lord Carnwath, I suppose.
Sorry?
It's always Lord Carnwath.
It's Lord Carnwath in N and Lewisham.
Yep.
And it's where he says that it takes me a moment to find find the quote, but he is essentially saying, and I do apologise, I'm paraphrasing, that one of the principles of statutory interpretation can apply where there has been settled practice in the form of an authoritative decision of the lower courts upon which the businesses and public authorities have regulated their affairs since then. We say that that test can't be made out here. We say that there is the only decision of a lower court that could be said to be authoritative is the decision of the Court of Appeal in this case, because the point, insofar as it was raised previously, was raised in Ravichandran and Lewisham and in 2009, and the Court of Appeal found in Ravichandran that there was no automatic cessation. So we say that if local authorities have organised their practices on the basis of automatic cessation or prospective decision, it can only apply since the Court of Appeal in this case. And that whilst that may be authoritative, that's a matter for my lords and my lady to decide. It's not for a significant period of time, clearly. And we also say that the evidence, both from Shelter and from the second interveners, whilst the evidence from the second interveners is a little more nuanced about the practice in 14 London local authorities, of course the very hard-pressed ones, but that evidence does not show settled practice. If it shows anything, it suggests settled practice is in accordance with our contention that there should be a decision post-offer. That's what the vast number of local authorities replying to Shelter said, over 80%, including, and they said that they sent letters in both circumstances of refusal and acceptance. So we say that the submissions on settled practice by the second intervener, that's our answer to them. I've made my submissions on notification by referring my lords and my lady to Anu Frieva and D4. Would my lords and my lady give me one moment? Anything else? No? All right. So, just final conclusion. This is about statutory interpretation as to proper decision-making under Section 193. What it's not about is expanding the categories of people who might be entitled to homeless assistance. It's not about trying to persuade this court that local authorities shouldn't use certain units of temporary accommodation. We accept just how hard-pressed local authorities are. We say that what we are contending for, that local authorities should make a decision and should notify a decision post-offer, is not an onerous burden on local authorities, and that is what the Deputy High Court judge found. And we do say that the alternative, as contended for by the respondents and in respect to ground 2 supported by the second intervener, that's the set of scenario that can lead to judicialisation of disputes, to uncertainty for both parties about whether or not duties have ended, and therefore uncertainty as to whether the simple route of a review, which is a safeguard for an applicant and is a simple form of resolving disputes over fact, that their contention leads to that uncertainty, and our contention leads to clear certainty that decisions are reviewable, which is absolutely what Part 7 had in mind in order to avoid over-judicialisation and the proliferation of judicial reviews. And on the particular circumstances of this case, if my lords and my lady are with me, then we simply ask that the Court of Appeal order be quashed and that judicial review is allowed. As my lords and my lady know, the matter is now academic for my client. She has a council tenancy, so we don't ask for a declaration. Is there any other matter I can help?
No, we're very grateful to you for all the assistance you've given us.
I'm very grateful indeed.
Thank you very much, Ms. Davis. Ms. Bates.
Case of real practical importance for homeless people and homelessness decision making. There are two parts to the submissions I'd like to make in my half an hour. First, and probably most importantly, is to take you through how Shelter says the Act works. And it seems to me, in some of the exchanges I listened to from the court and my learned friend, we need to be clear about the difference between decision-making and notification. And we'll take you through how Shelter says the act should work. Secondly, time permitting, I want to address you briefly on some of the practical implications of this, and suggest that this isn't a particularly revolutionary approach, what Shelter is asking for. This isn't a particularly bold reading of the legislation. This is largely in keeping with what actually happens on the ground. Can we start, if I may, with section 193? And for present purposes, can we use the current version of it? Because the provisions we're looking at haven't changed materially. So if we go to 534, and as my learned friend Ms Davis said, although this is a 7AA case, that the logic, it seems to us, applies equally to 6 and 7. If we can just look at 6 for a moment, the 5 ways in 6 that the duty ceases, so the authority ceased to be subject to the duty, all in our submission involve someone, the local authority, having to decide something. None of these state of affairs come about naturally with an automatic piece of paper popping into existence. They're all the result of a process. Someone has to decide that the homeless person ceases to be eligible for assistance, so someone has to interrogate their immigration status. Someone has to decide they became homeless intentionally from accommodation that was provided. And same with C, double C, D. And you can make the same point for 7 and 7AA. In 7, someone has to decide there's been a refusal of a Part 6 offer, and in 7AA, you have to decide that the conditions have been satisfied.
But they have to decide before what happens.
And this comes next. So this is the first stage. Stage 1 is someone, i.e. the local authority officer, decides that one or other of those conditions is factually met.
I mean, that's stage 1 of a decision-making process. It's not stage 1 of the legal analysis, is it?
Well,
and stage 1 of the legal analysis is whether one of these preconditions exists.
The two of them are interrelated. So someone has to, the local authority decision officer, has to have decided that you cease to be eligible for assistance. And if that happens...
I'd just like to hear his second and third statement.
If that conclusion is reached, there may only be one outcome which can happen, because 1936A specifies the outcome, which is that the authority cease to be subject to the duty. But none of these state of affairs are akin to the sun rising in the morning. They don't happen naturally.
It's the same confusion as we had before. Whether somebody, whether the local authority, we're told that the housing authority ceases to be subject to the duty if the applicant ceases to be eligible for assistance. Right. Now, none of that depends on any human being doing anything. That's simply a proposition of law.
But someone has to conclude you cease to be eligible. Or alternatively,
the person ceases to be eligible. Sorry, the housing authority ceases to be subject to the duty if the applicant ceases to be eligible, not if the authority decides, because the authority's decision could be right or wrong. But the only reason why the authority takes a decision is because of a rule of law. It's trying to apply the law to the facts.
I still say there has to be a decision. I'm going to come back to this in a minute, because there is a Court of Appeal case that you haven't been taken to yet, where Lord Justice May inches very closely, I think, to answering the problem that's troubling my Lord. But the starting point in our respectful submission is that that state of affairs which gives rise to the discharge of the duty has to arise. And we do say, as a matter of practicality, that requires there to be a decision. The more important question in our submission, though, is the one that was troubling, I think, all of my lords, and particularly my lady, the question of cessation. And Shelter here does say that even if the authority has, on our case, I appreciate my Lord readers may not agree with me on this, but even if there has been a decision that someone ceases to be eligible, the duty does not end until that is notified to the affected person. And we say that for two reasons. We say that is the position as a matter of fundamental constitutional right, the Anna Frieva case that I'll take you to. Secondly, that conclusion is necessary to make the proper working of Section 202 efficacious. And that's why, to come back to my Lord Reid's difficulty.
Well, I don't have a difficulty. I mean, obviously, the law, in order to apply the law to the facts, the housing authority has to take decisions. And the moment it does that, the possibility of review under Section 202 is open.
And it's that way of expressing it isn't one that Shelter has a difficulty with. And that way of expressing it latches onto, in my submission, the critical point. It's the consequence of the state of affairs having arisen. And the consequence of the state of affairs having arisen in our submission is that there has to be notification to the homeless person, including details of their right to challenge it under the statutory scheme. So in my submission, the court started with its questions to my learned friend, Ms Davis, in the right place. It is Section 202. That is the central answer to this case, because that is the most important part of how this scheme works. So if we go to page 559, it's Section 202 that was actually the radical intervention in the 1996 Act. It doesn't exist in the 1977 Act. It doesn't exist in the 1985 Act. It's Section 202 that was actually the important reform. Lawyers focus on 204 because it moved things from the High Court to the County Court. But this was intended to be...
Well, you can take it, we're focused on... I think we all are aware of the background to 202 being introduced, and we appreciate its importance.
The critical point is 202(1)(b). No one disputes the court, no one's challenging in this appeal the Court of Appeal's two decisions in Wasame and Ravichandran that 202(1)(b) includes a right to seek a review of a decision that a duty that was once owed has now ceased to be owed. So all of the conditions in 1936, 7 and 7AA, all of those circumstances that ended the duty can all be the subject of a review under Section 202(1)(b).
I mean, the whole point of 202 was to divert cases from the administrative court to the county court.
No, my lord. That was 204. 204 is what moved jurisdiction from the High Court.
Yes, I mean, the two work together. You start off by having a review by a local authority, and then you can go to the county court if you're not unhappy with the outcome. And so the policy behind it suggests that 202 and 204 should be given a very wide application.
Correct. And Shelter wouldn't.
I mean, Section 202 is really there to try to spare the administrative court.
Yes.
Because mistakes arose. It was to give local housing authorities an opportunity to correct those mistakes. If they would correct them, no one needed to take matters further.
That's certainly part of it. I wouldn't disagree. I'd actually say it was slightly broader than that. In our written materials, we draw attention to a case called Sidonia. In our case, it's just for notes, page 127, paragraph 25 of our written material. What was said in Sidonia is that it was actually as much about the homeless person as well. It's their last opportunity.
Yeah, I mean, the homeless person wants the rights, well, usually wants the right decision, and it's, again, much speedier than going off to judicial review to ask the local housing authority.
Quite, and it's the centrality of 202 that matters. So 202.1, all of 202.1 is predicated on there being a decision of the local housing authority. So that's why I think there may be less between us than perhaps I feared, but that's why I do say to my Lord Reid that there is still a decision, because that's the gateway into this.
Yes, you're not going to encounter an argument with me on that point.
So the decision for 202(1)(b) is the decision that a duty that was once owed has ceased to be owed. So that's the decision that has to be made for that to come into play. So the authority, that's why we say that
Well, no, it's not limited to that class
No.
of case, in fact. I mean, just reading the words, decision of a local housing authority as to what duty, if any, is owed to him. So a duty may never have been owed. The local authority may say, we don't owe you a duty, but he may wish to challenge that.
my Lord is, of course, right. It encompasses and includes a decision that a duty that was once owed has ceased to be owed.
Yes.
So therefore, Shelter says, QED, that means, therefore, that if you are going as an authority to conclude that by operation of law or by the local authority's assessment of the facts of your case, i.e. that you made yourself intentionally homeless from accommodation they provided, there is still a decision to that effect. The decision is that because of one of the things in subsection 193.6, 7 or 7AA, you are no longer owed a duty. You are entitled to receive notification of that decision, because without it, 202 doesn't work.
Well, well, you say that, but I mean, why doesn't it work? So take the offer, the June 2020 offer here. It's all spelled out that if you don't accept this offer, and it's explained what you have to do to accept the offer, the duty will cease. So, I mean, why isn't that reflecting a decision as to what duty is owed to him? It will, in fact, reflect a decision-making process, because the local housing authority has to go through the subsection 7A and 8. Sorry, I probably missed 7F and 8 to make sure that the housing which is available under the private sector rental is suitable. So they've had to go through a whole mental process. Yes, it looks suitable. We're now going to explain that you've got to accept or not accept this offer. Either way, our duty is going to come to an end.
So there's two answers, my Lord, as to why that sort of prospective decision, as we've been calling it, and then I know my lady wanted to come in as well, so I'll come back in a moment. There's two answers to that. The first is the wording of 202.1b itself. What duty, if any, is owed? And the letter that you're describing, and Shelter takes no position on the facts of this case, but the letter of the sort you're describing is a common kind of letter. That's not a decision that a duty is owed. That's a decision that a duty will cease to be owed in a future event. So it doesn't fit with the language. But secondly, it doesn't fit with 202.3. And this picks up on a point my Lord Stevens put to Miss Davis earlier. 202.3 details how you request the review, and it has to be before the end of the period of 21 days, beginning with the date of notification. I'll come to the extension in a minute, because that mission isn't the answer that my Lord Stevens suggested it might be. So those prospective ones, the question is, when does the 21 days run from? Is it from the date of the decision, of the letter the authority sends you, in which case you will almost invariably lose some of your 21 days while you're making your arrangements to travel up to see the house, arranging childcare so that you can be free to go and do it? Or does it run from some later date? If it runs from some later date, there needs to be a notification of it. It seems to me that if you're agreeing with what my Lord has put to me, that if we're taking 202 to have the most generous interpretation possible, an interpretation whereby you can lose 2, 3, 4, or even more of your days whilst you're making arrangements to see if you want to accept this offer or not, doesn't seem to fit with that. And in answer to my Lord Stevens' point, to my learned friend about judicial review, the difficulty I would say with that is, one thing we all know is that the conscious choice Parliament made in 1996 was to try and stop these cases going to the administrative court. Opening up a situation where it is easier to have arguments about whether the 21 days should be extended, which will have to be judicial review cases, seems to me a much less likely parliamentary interpretation.
I don't understand that at all. The local housing authority has got a power to extend time.
They do, but if they don't do it,
Yes.
your remedy is judicial review. And one of the things that the 1996 Act wanted to do is to limit the role of the administrative court in housing cases. So if we're going to ask the possibility of challenging a failure to extend time to do a lot of the heavy lifting, we have to grapple with the fact that Parliament did not want the administrative court playing a large role in this scheme. Sorry, I see my Lord drawing breath. No, sorry. So that's the short answer to it. This isn't a scheme that's designed to trouble the administrative court frequently. The administrative court's role in Part 7 is supposed to be residual, rather than being, what on this would become, the primary mechanism for disputes for those cases around whether the time should be extended. Much, much more simple to say. There will always be a decision that the duty has ended, and then your 21 days run. I'm conscious that my lady had a question a moment ago, or started to draw breath before Lord Sales spoke.
Yes, I'm still... The question about whether there has to be a decision that the duty has come to an end before it actually comes to an end. Just going back again to the, I know it's not our case, but the hypothetical case of the person who something has happened that they now cease to be eligible, and the duty comes to an end by operation of law. If they're in accommodation and they stay there, they don't necessarily need to be able to review that. What will then happen is that the local authority will become aware of that and will write to them saying, because you've ceased to be eligible, you now have to leave that property. Now, in that decision, an element in that decision, or a predicate for that decision, is that the duties cease to come to an end. And isn't that then how you get a review of whether that is correct? That the decision that is challengeable is a decision which is a consequence of the cessation of the duty.
Yes, yes, I'd be very happy with putting it that way, yes. That doesn't, though, obviate, in my submission, is a more important question, which is how does the affected person know about this? It's why in our written case we only talk about notification, because that's the actual practical answer here. Can I just take you to a case called Deugi in the Court of Appeal, where the Court of Appeal inched towards this very problem that you're now grappling with. It's at 779 in the authorities. And it is an eligibility case where status changes. That's paragraph 33. 3 lines down, starting by then circumstances had changed. Tower Hamlets considered Mr. Deugi was no longer eligible for assistance. If that was correct, 1936A supplied the statutory consequence. Tower Hamlets has ceased to be under the 1932 duty. Tower Hamlets didn't need to withdraw their earlier decision for the consequence to apply. And then this part is what we're grappling with in this appeal. 1963A may theoretically not even require a decision, although no doubt the local authority in practice needs to communicate its view. 2021A seems to contemplate a decision. 1936A does not, it seems, give the authority discretion. There may well be a dispute about whether the authority has ceased to be eligible. And then this is the important bit. Once the authority communicated its view or decision, Mr. Deugi was entitled to request a review and thereafter to appeal if she was dissatisfied. That's right. It's the communication that's the critical bit. And that's Shelter's submission. Because it's the communication that triggers, when the communication tells you, you are no longer owed a duty. The reason for that is you're not eligible, you make yourself homeless, whatever it may be.
But in our case, there's been a communication by the offer letter. So does the argument come back to your point that it can't be prospective?
Yeah, well, Shelter doesn't have permission to intervene on ground 2. But yes, if you were to ask Shelter, Shelter says you can't have prospective decision-making. It envisages a decision, and it envisages 21 days running from that decision. In order to avoid disputes over when the 21 days runs for, and in order to avoid troubling the administrative court, there should be a letter setting out the decision, and then we know when 21 days runs from. In our respectful submission, none of what we're saying here is new, revolutionary, or radical, but the importance of notification, we say, is well settled. And if I can take...
What the case you've just taken us to is entirely consistent with what I was suggesting to you earlier. That obviously the local authority, in the real world, it needs to take decisions. And the minute you communicate the decision, there is the possibility of the person affected seeking a review.
then, my Lord, I'm happy that there's much less between us than I thought there was, if the error was mine in not understanding the point. But we say that's part of...
I'm sorry, just to really add to the point, I mean, I just thought section 2023, which says a request for review must be made before the end of the period 21 days, beginning on the day which he's notified of the decision, is predicated on the idea that something has been notified.
Right.
And time doesn't begin to run until it is.
And that's Shelter's point, the notification is key, but in answer to my Lord's question, it's notification of the decision, not of the possibility of discharge if you were to do one of the two things identified.
Even though that reflects a decision.
Well, it's not a... That is not a decision.
I'm just to put the point to you, and then you can deal with it. There's been a very precise decision-making process that lies behind the offer in June 2020 because the local housing authority had to satisfy itself that the alternative property was going to be suitable accommodation. So they've gone through that whole mental exercise before they write the letter of June 2020. I mean, one might think that the letter of June 2020 very specifically reflects a decision that's been made.
So, my Lord, Shelter takes no position on the facts of the appeal, and it would be wrong to do so. But the point my Lord is making is a more general one. This is a fairly common form of decision letter. No one's suggesting this is some out-there letter that was of wonderful quality or of particular poverty. This is a fairly common form of local authority letter.
Yeah.
Shelter's answer is the short one. You cannot have prospective decision-making.
Okay, that's what it comes down to. You can't have prospective decision-making.
You can have indications of views, you can have encouragement to encourage people that they're warned that if they turn it down, they're likely to find their duties discharged. But what is envisaged is a decision, which is a decision that the duty has ended, and a date for that decision from which we can calculate the 21 days without the homeless person losing some of the time.
And where do you get the singular a decision from?
I'm not sure I follow my order.
2021B is any decision.
I'm not sure there's a difference between my formulation and what says in the Act there. A decision is any decision. I think the reason the Act has any is because you might have a decision letter that includes a decision on more than one point. I have no difficulty with the idea with a decision letter that says, firstly, no duty is owed because you are not eligible. Secondly, if that's wrong, no duty is owed because you turned down a suitable offer. I can see plenty of homelessness cases where you might have a series of decisions. I'm not suggesting for a second each decision requires its own letter, but there has to be, you haven't got to put 10 in the post and send them all at once, but you do have to tell the homeless person that the authority considers that 1936, 7 or 7AA are met. The consequence of that is that no duty is owed and that they have the rights under section 202. Otherwise, the whole scheme just doesn't work in our submission. Just briefly, in my last few minutes, I do want to explain... Just
before you move away from this point, what do you say about section 1935, well, 5 generally, 5C in particular, sorry, page 535, where there's a specific condition written into the existence of the duty, or sorry, the cessation of the duty, that the authority notify the applicant they regard themselves as ceasing to be subject to the duty under this section?
So, there's three answers to that.
Yeah.
The first is this section wins no prizes for clarity or intellectual coherence as a result of the numerous amendments over time. Secondly, it is plausible that Parliament may have wanted to spell that point out explicitly in 1935, but rely upon the Anna Frieva case for the others, because 1935 is a different kind of housing. 1935 is moving you between temporary accommodation. So it's never about ending your duties, 1935. So we'll put you and your family in a bedsit for 2 nights because that's just about suitable for 2 nights. Then we'll move you to a 1-bed, and then in 2 months' time we'll try and find you a 3-bed. You do all that under 1935. 6, 7, and 7AA are how you take them out of Part 7 completely. You end the duty. So because you're almost inevitably going to be offered the worst kind of accommodation under 1935, because it's the TA moving power, Parliament may well have thought you need to draw things out. The third answer is the Anna Frieva point, which I do want to end within my 5 minutes. In our respectful submission, the starting point is that as a matter of fundamental principle, decisions by public authorities do not take effect until they are notified to people. And if we can take this from page 1220, I don't mean 1220, that's the wrong bit. Where's it gone? Imam. Do I mean 109? Anna Frieva, where's it gone? No, 1103, thank you, Nick. There you go. Thank you very much, Mr. Brandy. Of all the times to find a typo. So, in Anna Frieva, the question here was that entitlement to welfare benefits for an asylum seeker ended when their case was recorded by the Secretary of State as having been determined. That was the statutory language. And what had happened is the Secretary of State told the benefits authority, but not the individual, which resulted in the benefits stopping without the individual concerned knowing. And what the House of Lords held is that there's a public law duty to notify the individual, even though the provisions in question didn't say that. And most importantly, it was notification which was required to make it an effective decision. And if I can ask the court to read to itself paragraphs 26 down to 31, 33 and 34, sorry, 33 and 43, but with one eye on the time, I'll just identify the passages I draw particular attention to. In 26, I draw attention to the passage, that is a fundamental and constitutional principle of our legal system. In 28, at H, that is not our system, down to, if this analysis is right, it engages the principle of construction explained by Lord Hoffman and ex parte Sims. Ex parte Sims, of course, is the presumption that common law rights not to be thought to have been taken away by parliamentary sidewind. Paragraph 30, until the decision in ex parte Salem, it had never been suggested that an uncommunicated administrative decision can bind an individual. It is an astonishingly unjust proposition. Where decisions are published or notified to those concerned, accountability of public authorities is achieved. Elementary fairness therefore supports the principle that decision only takes effect upon communication. And then 31, it is in effect one involving a binding determination as to status. It is of importance to the individual to be informed of it so that he or she can decide what to do. All of that applies equally to homelessness law, as it does to welfare benefits law, as it does to immigration law, and the other cases we've drawn attention to in our printed case, where this principle has been applied. So a rather long-winded answer to my Lord Lords of Sales, but that was the third point in there. Parliament doesn't need to spell it out. It is a fundamental principle of law unless Parliament has expressly obviated the need for notification. My Lords, I'm conscious that I have 1 minute left. I'm not going to try and start dealing with practicalities, save to note that Shelter in their FOI submissions, in our written submissions in particular, draw attention to page 130, paragraph 35A. We don't pretend this is doctoral level analysis. This was an FOI request of local authorities, but just shy of 90% of authorities who responded say that in some or all cases they send 2 letters. This is not a radical thing Shelter is asking for. Most authorities already do what we say the law is. My Lords, I'm grateful. My Lady, I'm grateful.
Thank you, Mr. Bates. We'll adjourn and resume at 2 o'clock.